We back again. Hidden Black's Law. Google Plain Sight. This your boy Bob. Quick disclaimer as usual. Just so you know. Our videos should not be construed as legal advice. They are merely a presentation of the facts as we understand them. We are not attorneys, and you should seek advice from legal counsel, a legal professional, if you feel like you are a victim of misconduct. The facts presented here in our videos are not indicative of our personal opinion, and we do not always agree with the outcomes of the people, the legal system, and is subject to our interpretation of the courts. The legal topics covered here are designed to be educational, informative, and should not serve as legal advice under any circumstance. The contents of our videos are in no way intended to provoke, incite, or shock the viewer. The videos are created to educate citizens about their constitutional protections, activities, law, and civilian rights, and emphasize the importance of constitutional awareness. So again, thanks everybody for tuning in. We are here, Hidden Black's Law, Google Plain Sight. We back in the building, and y'all know how we get it in. You know, we always go back to the source. We go back to the source. And that's what I want to share with y'all, starting this thing off this morning. What's happening, boss?
Okay. All right.
Plain Sight.
Yes, sir. Good morning. Good morning.
Good morning.
So, as per usual, we got the strongest legal opinion out there. This is like the golden key to freedom and liberation and separation from the system as they have it. So I'm gonna go ahead and read this judicial verdict here for you. So right here you have in front of you a case of Hale versus Hinkle, which was held in 1906. Hale versus Hinkle was decided by the United States Supreme Court in 1906. The opinion of the court states, the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to incriminate him. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by law of the land, i.e. common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. And once again, underneath that, you got a little bit of background on the case. Basically, it's saying it's binding on all the courts of the United States of America until another Supreme Court says it isn't. This has not happened, and probably could never be seen happening as long as the Constitution reigns supreme in the nation known as the United States of America. No other Supreme Court case has ever overturned Hale versus Hinkle, and none of the various issues on it. So all of those things stated therein have all been founded to maintain their trueness from 1906 on to this date. It's been cited probably in the neighborhood of 2,000 times.
Bang, there it is. There it is. The truth shall set you free.
So yeah, just want to give you the audience out there what they need to understand as their paradigm That's how you need to approach the court, understanding your full ability and a power to advocate for yourself. Just like in chess, you wouldn't want to go into a game not understanding how the knight moves or not understanding how your queen moves. That would leave you handicapped. Why would you even jump on a chessboard?
Right.
So yeah, understand your moves in the game. That's a major key.
Oh man.
So yeah, we didn't even really allude to it just yet. Today, podcast is going to be on jurisdiction, understanding, and basically actually tying back into that whole Hale versus Hinkle matter. Jurisdiction is basically tied into your individual agency because it's right there in the Latin. Jurisdiction. It means just or proper speech. Basically, the one who says things are so, and so it is.
Mm-hmm.
So if you understand jurisdiction, you'll understand it as basically like my house, my rules. That's something your parents tell you. You know what I'm saying? When you're at your parents' house, you're living underneath your parents' jurisdiction. So oftentimes with the government, they would have you think that you're in their house, so you have to abide by their rules. But oftentimes that's not actually the matter. But if they talk to you as such and you understand it as such, they already have they have a leg up on you.
Mm-hmm.
So we're gonna go ahead and get into. Oh, there you go, Google there. All right, bet. So we're gonna go ahead and get into some of the concepts that power the narrative of jurisdiction in general.
All right. You want me to put up the first one or?
Yeah, you want to get into these because so they talk about the types of jurisdiction, and you will find that there's several definitions that are very loose. And what I went ahead and did is sought the most clear and
Concise.
comprehensive way to concise. Yeah, that was good. That route actually. Yeah, clean cut understanding of what they mean when they state that there are multiple types of jurisdiction. Because even that statement in and of itself is a bit misleading. So why don't we can run those down right quick.
Those 4 that you sent me or the ones from?
Yeah, the 4 that I sent you just now.
All right, perfect.
You already went over the definition?
Oh no, we didn't go over the definition. Oh yeah, I did. I really just did.
Okay. All right. I'm sorry to just get in, I had a little bit of issue, so I had to make sure I took care of that first.
Yes, sir. Yes,
oh yeah, so it's funny here. So I was talking to Bach and I gave like a very what's the word I want to use? Like our practical application.
Mm-hmm.
I went ahead and used the statement you probably heard your parents say to describe jurisdiction. You might often hear them say, "My house, my rules."
My rules. Yeah.
Yep. Mm-hmm. So that was the way I gave them the understanding, and that's pretty much how jurisdiction runs. So it's authority. All right, bet. So there you'll see within the past couple of decades, they moved it into discovery, which is also an arraignment, but that's the ability to challenge the jurisdiction and the venue of the court. And they tried to shuffle it into a matter so that you couldn't just basically challenge jurisdiction outright, but it can always still be done. So that's a modern tactic that they've used to kind of keep jurisdiction out of your hands if you don't know how to advocate for it.
Did you already go over the whole you can challenge jurisdiction at any point in time, no matter what?
No, we did. I did not.
Let me. I have it's on those ones I sent you also. The one a court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal. It's in its power to act. A court must have authority to decide the question in first instance. Yep, right there. A court
There
has
it is. Yep.
no ability to decide their own jurisdiction. They must have facts. Jurisdiction is not somebody in the court just saying, "Oh, I have it." That's not how it works. They will tell you that. If you actually ask for jurisdiction, they will literally say, "Oh, they will never answer the question." I promise you that. If you ask, "Can you show me where you have jurisdiction?" They will never answer the question. They will talk about everything under the sun but that question. Because as long as they never actually answer the question, they never have to actually prove it. The burden at the last one, you can see it right there. The burden shifts to the court to prove jurisdiction.
Mm-hmm.
You don't have to. You don't have to prove they have jurisdiction. They have to prove they have jurisdiction.
Wow.
If you want to make everyone in the courtroom sweat, go ahead and put it onto the docket that jurisdiction is being challenged,
And keep repeating it. Keep repeating it, because like I said, what they will do, they will never answer the question. What they will do is postpone the case. Practical application, I've done this. They will postpone the case until another day. They'll try to postpone. They'll be like, "Oh, well, yeah, we'll just put this on a different day, could reschedule," because they're thinking that you will not have the funds to get an attorney to keep on going through the court system. So what they'll do is try to make you spend as much money as possible to fight the case. Because as long as they can keep it going, you always have to get, quote unquote, an attorney to represent you in a court case. So, or you have to lose money because you're missing work, because you have to keep coming back. So when you have to keep coming back, you have to keep spending money. The court has an infinite amount of money because they have your money. You already gave them the money to keep doing it.
Oh man, that's funny.
They're using your tax money, right? They're using it against you to make sure that you stay in court. So you paying twice.
Oh man, you just brought me to one of the main rules from those the background I was reading, and the one that I didn't post in there was one of the rules of the game is there is no money.
Yeah.
But I mean, as you know, with the court creating bonds in every matter that they bring forth, it's its own money printing machine. So yeah, we already have that established.
Yeah, you print the money as soon as you are the money machine. You are the social security number. You are the state, the United States holding financial interest in the stock market. Your work, your labor, your name, the name you use, I should say, is all what they use to create the funds that they use against you. Isn't that crazy?
Yeah.
The funds they use against you are created by you.
That's insane.
Original stock market is you. That's just wild.
Yeah. You can, Bach, can you go ahead and pull that one back up where you had the jurisdiction where it had Monroe? Yep, right there. At the bottom it says it's impossible to prove jurisdiction exists absent of a substantial nexus of the state, such as a voluntary subscription to a license. All jurisdiction of facts supporting the claim of supposed jurisdiction exists must appear on the record of the court. So that goes back to the whole thing where we're saying you have to have a contract. For them to try the case, your contract must be proven. So we can go back to like the practical application. I took it upon myself to give the state a contract that they could sign or not sign. Either way, it's still valid. It's still an agreement. If it's not a contract, it's an agreement. Either way, I still win. So with that, they have to prove jurisdiction. Well, if they don't sign the contract, they prove they don't have jurisdiction. Automatically off break. So if I ever go into a courtroom, all I gotta do is present that document and not say a word. And that's like I said, if I decide to show up at all. because I have proven they don't have jurisdiction. So they have to go against the document and show some kind of tangible evidence that they have the right to tell me what to do.
Which is funny because it can't be done.
Exactly.
Well, I mean, hey, it is impossible to prove jurisdiction exists absent the nexus with the state. So if you drew up the contract and they didn't agree to your terms, there is no agreement.
Yep. For a contractual agreement to be valid, there must be a meeting of the minds. It must have consideration. Both parties have to be getting something out of the deal and have to agree to it. If there's no agreement, there's no meeting of the minds, and anything other than that is void.
Did you want to hit that one joint? It was like the very first one about the burden about who's proving jurisdiction being the person who asserts it.
Yes. You can.
I mean, it's a more basic premise, but I mean, we should have probably led with this one, but it's just kind of.
Well, it's a basic yes. Can you go ahead and show the people that for me, Bach? I don't mean to put you on the spot, to be over here narrating, but the burden of proof,
Jamie.
Yeah, the burden of proof, the burden of providing jurisdiction rests upon the party asserting it.
This is like
the court must prove on the record all jurisdiction of facts related to the jurisdiction asserted.
And here comes that point you were just making about jurisdiction there right after, if you want to continue.
Go ahead and read it.
All right. However late this objection to jurisdiction has been made or may be made in any cause in an inferior or appellate court before the United States, it must be considered and decided before any court can move one further step in the cause, as any movement is necessarily the exercise of jurisdiction. They can't even move forward in the matter towards, they want to get you with convictions, this, that, and any decision regarding law or legality cannot be pressed without them establishing jurisdiction once the question has been raised. So that's in a nutshell.
Yes, it is a complete stop. It's like if you put the emergency brake on a train while you're moving. You going down the railway, you on Metro, and they said, "Hey, I need to see proof of jurisdiction." You just pull the emergency brake. Train ain't going nowhere.
Oh man,
the train ain't going nowhere. That joint on full stop. Yep, full stop. It can't get back started until they prove it, and then that's what they say. Everybody off, and you gotta walk to the platform.
Yeah, like imagine stepping into a courtroom and the state's all there, and you just have a force field on you for all that stuff that they're talking from around you in the courtroom. That's claiming for jurisdiction right there, because if they have to prove it, they absolutely cannot. So all that, everything they're saying to you is pretty much just falls on deaf ears, if you will.
Practical application. I can give you an example. So, you know what? I'll say that. I'll tell the whole truth, and nothing but the truth. I had a governmental position offered to me, and it was I forgot what their the position. I can't remember. When you're going the first person when they arrest you, they try to take you commissioner. Excuse me. It was commissioner. It was a commissioner position. It was a commissioner position. So I had an offer for a commissioner position. Only issue was I was not in the county. You have to live in order to get a commissioner position with a county or actually with a county. You have to live within that county. Now, the county position that I had been offered was I think it was Caroline or Anne Arundel. I can't remember. It was either Caroline or Anne Arundel. But either way, I don't live in either one of those counties, right? So couldn't take the job. I end up getting stopped. Of course, because I look at me, I'm dark. I end up getting stopped, and so I come, I whatever they say, whatever case, whatever. I pay no mind. Eventually, I think the sheriff had came to my house. My wife and I were home. I'm doing yard, whatever, and they had a warrant for me to come in for my arrest. I can't even remember why, because literally it was basically a traffic stop. So the reason they got a warrant for a traffic stop is a whole crazy issue in the first place. But anyway, so I end up going to the commissioner because I was like, all right, you know what? I don't really care right now. It's a weekend. I'm trying to hurry up and get this thing over with. I'm not trying to talk to anybody. I don't have to do anything. I'm not going to tell him go home. Give him any kind of license, because at this point in time I still had a license. I'm not trying to do all that because I got my neighbors outside. I am who I am. I can't make a scene. So I was like, all right, fine. Go. I have to go before the commissioner. Mind you, this was the job I got offered. So I have to go before a commissioner for a position I got offered. So while I'm there, I'm smiling. I'm kind of like laughing in my head because I'm like, the only reason you have this position is because I decided not to. And
Wow.
I declined it. I had to decline it. That's the only reason you got the position in the first place. So I ask her while I'm there, I'm like, do you have proof of jurisdiction? She goes on to say, I don't know what you're talking about. Because, mind you, you can challenge jurisdiction at any point in time. You can challenge jurisdiction at the arraignment. You can challenge jurisdiction as soon as you're arrested. You can challenge jurisdiction whenever you want to. Because anything that they're trying to do legally has to stop the moment you ask or challenge jurisdiction. You have to prove your jurisdiction. It has to stop. Any court case. If they're doing things legally and lawfully. Now, will they? That's a question right there. But, so, when I start asking, I ask a couple times. The sheriff and I had been talking the whole ride. He's about to retire. He doesn't even like the people that's still working. He's a deputy at that point. It's a deputy for a sheriff's department. He's trying to retire because he is tired of all the new people that they're hiring going, as plain sight would always say, beyond the stop. Because they love to do that, go beyond the stop. They stop you for one thing, and then we're going to try to search and try to find and try to write you up and try to give you as many tickets as possible and throw them against the wall and see which ones stick.
Mm-hmm. Mm-hmm.
So he's like, he doesn't like all that. People trying to ruin lives. They don't understand that what they're doing is not helping anyone. So, we said, we had a good talk. We were just talking, whatever. And he's trying to tell me, hey, as soon as you get done with this, I'll give you a ride back. It's not even a problem. Just, come on, let's just go home. I know you want to go home. He's trying to coerce me into, just saying whatever's necessary. So that way we can get this handled so they can get it the way they want it to be.
Go with the flow.
Go with the flow. Go with the plan. Come on, dude, just go with the plan.
Let me get along.
He's like, because they both know that the fact that I'm challenging jurisdiction means I actually do know what's going on. So the only thing they have left on the table is coercion and threats. Threats, arrest, and coercion.
Mm-hmm.
Always remember that. Threat, arrest, and coercion. Because you cannot sign anything legally or be found held accountable for anything that was done under threat, arrest, or coercion. But we talked about that previously, but anyway, so I come to the point where I understand that actually, in fact, she does not know what I'm saying, because she is not. To get a commissioner's position, you don't actually have to know any kind of law whatsoever. It's just a pretty much elected position, right? You don't have to know anything about law whatsoever. You can be somebody guy off the street. Commissioner you don't have to know anything about law. So as I'm talking to her, I can understand from the conversation I'm having with her and her not understanding any of the words I'm saying, because she doesn't even know the definitions of it. And I can tell by the way her mannerisms and her facial expressions that she actually has no clue. Is what I'm saying. I was like, man, you know what? It probably is better that I just go home because this is not going to get him today. You have no clue what's going on, what's being said. So I'm agree with him. Yeah, we're all going to just go home because you are completely out of this right now. You're out of the loop. You're not even on the standing of someone who is acting honorably. So
The zombie life.
yeah,
Yep.
yeah. She's one of those. I'm just doing my job.
Mhm.
You don't even know what your job is, but I'm doing my job. So it's all that. So I end up just going home. You know, he drives me. Like I said, he takes me all the way back. Takes me all the way back home. You know, wife. You know, was like, everything fine. I was like, yeah, whatever. You know, they set a court date and whatever. Everything pretty much. I think I got like I said, this is back when I had a license. I got like a $20 fine or something like that. It was like, they always try to get me over the head. They try to tell me I got to pay some hundreds of dollars or whatever, or almost $1,000 and some time in prison. And then when I actually get done with everything, this is when like I said, when I had a license, it always like get bumped down to like $50, you know, 35, 36, 36.40, you know, court fees and court costs, you know. So it's like, it's different when you understand what you're saying because they're more likely to do stuff that is at least somewhat comparable and gives you a way out than if you don't, because they don't want any pushback. They don't want any kind of, you know, messages getting out there.
And they don't want you gunking up the works.
Yeah, you can't show us. You can't. It's like a TV show. You can't be taking down all the, you know, all the back screens and stuff like that and showing everybody this is just on, you know, this is not real.
Yeah.
Right.
Can't be exposing all the wires and stuff. Come on, man. We're supposed to be superheroes out here.
It's movie magic, man.
But that's just a little side. Sorry for going off on tangent, but yeah, just a little side thing about, you know, jurisdiction and how they will try to rope a dope.
So I guess all practical application, as they say.
So the burden of proving jurisdiction rests upon a party asserting it. The court must prove on the record all jurisdiction facts related to the jurisdiction asserted. However late this objection, man, remember, you can do it at any point in time. You can do it before you're even right before you're getting your verdict. You know, right before the judge decides, you know, whatever he's going to give you. Mind you, he's just a magistrate at that point, but you can do it right before that. So, however late the objection to the jurisdiction has been made, or may be in any cause, in an inferior court or appellate court of the United States, it must be considered and decided before the court case can move further a step in the cause. So, as you read, as we always say, don't take my word for it. Don't take Plain Sight's word for it. Take the court's. The court said it, not us. Don't be mad at me. If you have any gripes or grievances, Supreme Court would love to hear from you.
Oh yeah.
Take it up with Supreme Court. I'm sure they will listen to you.
Oh yeah, you want to get that last one right before we get into subject matter jurisdiction?
Which one is that?
I was going to say a court has no jurisdiction to determine its own jurisdiction for a basic issue.
There it is. Yeah, man, I gave y'all more information than I even knew.
It's always good to keep it
I like these, man, because it even has the, you know,
the case citation.
Yeah.
Mind you, that's the U.S. As you see, it says U.S. So it gives you multiple court citations. As you with most court cases, there are multiple citations where cases have cited the same case. over to make their rulings. That's how jurisdiction works. That's how a precedent works. And a lot of people don't understand what precedent is. When you have precedent, which means it has been decided already in another court, the same matter, pretty much. It has to be on the same, it doesn't even have to be the same. It's concepts of the same matter have already been decided in another court. What courts do most of the time is use that precedent to make decisions on their own court that they're doing at this moment. So if you have another case that has already been decided, well, I don't need to do any more work. I'm done. The work's already been done for me, so I'm just going to use this precedent and make it a court ruling for this case also.
Yeah, it's the good old legal maxim. Any law that was ever in law and never outlawed is good law.
Legal maxim.
Gotta love them.
A court has no jurisdiction to determine its own jurisdiction for the basic issue in any case before a tribunal. It's the power. It is its power to act, and the court must have authority to decide the question the first instance. So before anything can go any further, you must prove the jurisdiction. It must be proven. That is a maximum. That is law. That is not legal. Legal has no place in law. Even the bottom one, the burden shifts to the court to prove jurisdiction.
That's like the most. Yeah, that's the concise way.
That's the most concise way. The burden shifts to the court to prove jurisdiction. You never at any point have to prove it yourself, because you're not the one claiming it. The court is. So anytime they bring you to court, they have to prove jurisdiction, not you. They have to prove they have the right to decide the matter in the first place. Because according to every single constitution in the United States, for the United States of America, they say that everything that happens in life, liberty, and the pursuit of happiness happens at the common law jurisdiction. So if a court wants to bring you into the matter where they actually are putting you in front of nobody, they have to prove jurisdiction, because everything happens between men and women at common law. Everything that happens between citizens and property and businesses happens in admiralty law. So they have to prove they have the admiralty law jurisdiction first before they can move forward. That's never going to happen, because can't, because you're a man. And the one thing that you will ever hear them ever say in court: men or women, man and woman.
They love person. They love to refer to everything as a person.
Person, subject, citizen, individual. They will not say the word man or woman, because as soon as they do, they've already canceled their own jurisdiction.
Hey, I gotta read it because it was so good. I just thought that second bullet there is so good. Yeah. So, a departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form and methods of procedure with which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. So it doesn't matter how close they follow the form of law. The moment they split off and try to attempt anything on you without having jurisdiction established, they've transgressed against their constitutional authority. They've made a move against the Constitution, and they're now acting in dishonor.
Talk to them. Yeah.
Honor and dishonor two of some of the most important words you will ever have in court. Are you acting in honor, or you're acting in dishonor? Because now you have a claim that has been made that can be decided by a court, a higher court. Because your district court ain't even a court of law. Just for clarification, it's not a court of law. District court can never be a court of law. There is no jury present. No jury is deciding the matter. There's just a magistrate, a guy on a bench. That's not a court of law.
Yeah. As you've seen from several legal documents that we've posted, at the point that you are in a courtroom with a judge in a one-on-one situation, he is at that point acting as a ministerial clerk for the court. He's not a judge in their official capacity in those.
He's a well-paid clerk. He's a very well-paid clerk.
You know what the funny one is to me, anyways, because usually whenever men and women find themselves in the courts over matters like this, it's usually dealing with a traffic issue. And I love how they like to try to call it, like, what is the jurisdiction they're claiming when you're in that court? They like to call it criminal/traffic. So they like to mishmash, concepts to play the game and make you feel like anything in traffic has something to do with criminality. They like to combine, unlike things and put you in an environment that makes you feel as though they have some level of authority that is never actually present.
And they love to give you stories about it. A guy came in here the other day. He was in the court. He was claiming this and claiming that, and I had to tell him. I was like, you don't rule this court. So I gave him the maximum. Because he was just pissing me off. And sometimes you got to do that. I don't know what the story had to do with me. I don't know why you're telling it, but sure, go ahead. Because that's the part
can
of that
you
whole.
Go ahead and just prove jurisdiction for me, right quick?
Yeah, that's part of that coercion thing. They're going to tell you about a side story that has nothing to do with you. Because everybody wants to tell you a story about what happened to another guy or someone else, but you're not someone else.
Yeah,
that wasn't you. So, yeah, those threats, those side threats. They don't make direct threats, except every once in a while they'll be like, I'll throw you back in jail. For what? Because if they do, then they're acting in dishonor. Then you can always have their whatever being cited right there in that case. You can always have it dismissed by the higher court and have them overruled by the higher court, which no judge wants, because now it goes on their record that they have been making false rulings. But let's move forward.
I was about to say, you want to jump into the subject matter jurisdiction?
Yeah, subject matter jurisdiction.
Okay, all right.
Which one?
Let's see. Oh, because there's only two left, and they kind of like marry into each other pretty nicely.
All right, you can go ahead and read that.
All right, so do me a favor. Go back to the one just before this one.
All right.
What jurisdiction?
It's like if the court determines at any time it lacks subject matter jurisdiction.
Oh, if the court determines. All right, hold on, my bad.
Oh yeah, that's the last one. That's the last one I sent.
Okay, because it came to me in the reverse order.
Oh, yeah, so, right there. Yep.
There you go. Yeah, all right. So as you see there, if the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. And that's federal rules for civil procedure. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. So even if they've made a decision, once it hits the record that jurisdiction has come into question, they have to reverse everything and get back to seeking to know whether or not jurisdiction was ever established. And lastly here, thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. So what's that getting back to? That's me just talking about, why do they call it criminal traffic? Do they really have jurisdiction over the concept at hand? And that's the easiest one to bring up if you ever want to create. I mean, because the court has created controversy.
Yeah, about to say the same thing. Yeah. No, you're fine. Go ahead.
Yeah. So with that, you know, and all you want to do in the courtroom is you just seek to not create controversy. So if the court does, it's definitely an issue. So let's get that last slide. The last one should be the one where it reads, where a court failed to observe safeguards. It's got like a Merritt versus Hunter.
Yep, right there. Right before that one. That's a malicious prosecution. Go one up. Go right there. That one right there. Yeah.
Yeah, there we go. So yeah, where a court failed to observe safeguards, it amounts to denial of due process of law. Court is deprived of juris. Not every action by a judge is in exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void, of no legal force or effect. And that actually reminds me of that one case I saw where the dude had the judge so on the ropes that he asked him a question. And if you know anything about the rules of how these people work, he asked him a question on the matter, and the judge refused to answer. So he asked the question 3 times. At that point, the judge abandoned the bench. So the judge just creates some random reason to leave the courtroom. And so the man literally just walks over, dismisses the case, and bangs the gavel for himself. And he walked out the courtroom just like that. It was the wildest thing I'd ever seen.
There is a, I guess, unsaid rule that it must, if a question is asked 3 times, it must be answered. And if you don't answer it, then it dismisses everything.
Yeah, you've abandoned your position to the issue.
You've abandoned your post.
Yeah, and they'll pretend like they're going to do some reconvening or stuff, all that nonsense or whatnot. But yeah, if a question's been asked 3 times and there's been no response, that's the person in the color of state authority letting you know that they're abandoning their claim to authority on it.
Yeah, or they're acting in dishonor.
Yeah, they don't want to act in dishonor. Yeah, so
they don't want to act in dishonor. So what they do is they just leave.
They try to pull out a stalemate on you.
So if you, that's a whole nother thing. If you ask 3 times, they either answer it or they just abandon ship.
Wow. Crazy.
So let's see here. All right, I'm gonna see if any of that Yusuf L information I got there, particularly because I had earlier brought up the idea of there being types of jurisdiction, as we just covered the most useful one to have in your hand, or like the idea of is subject matter jurisdiction, because that gets into the nature of the matter at hand,
nature of the cause.
Yeah. And that is, I feel like most people have really lost the concept of asserting that needs to be ironclad before governmental entities move forward in anything they're attempting to do with you. So let me just let me see right here.
What is the nature and the cause of action?
Okay, so yeah, that was that actually leads back into that first one we had looked at when I was talking about when they tried to move the idea of being able to claim jurisdiction into discovery. But, as we've just already stated, that matters not. That's just something they do on a presentational level.
And they try to move jurisdiction into discovery for one reason. They don't always give the information under discovery, because even if you ask for it, they don't have to give it. Now, they have to give it, yes, but will they give it? That's a whole nother question. So if you try to move it to discovery, quote unquote, then you have already started the court proceedings.
Oh yeah, so and that ties perfectly into this one. Can you grab the one box where it say, this is because entering a plea accepts the jurisdiction? There you go. In this way, only subject matter jurisdiction is challengeable. If they say this is a matter at law, your defense against that jurisdiction is whether there is a live damaged party Do not ask if this is an equity jurisdiction because equity is not a criminal type of action. So, and that's that whole thing about not wanting to plead, because the plea is to contest. And once you contest the state in their claimants, you've created controversy. You're the one at dishonor now, and they flip the script on you.
So now you got to prove everything.
Exactly. So you don't want to enter a plea. A plea is a challenge to what they're attempting.
Guilty until proven innocent.
Yes,
exactly.
Actually, guilty until proven not guilty. There's no assumption of innocence in legal. There's no, and when you're doing with the legal system, there's no such thing as innocent. You can only be guilty or not guilty. Because if you say innocent, they will get pissed off. They will literally get pissed off. If you say I'm innocent, they'll be like, no, I asked you, you only have 2. Excuse me, 3. Technically you have 4, but that's a whole nother issue. Guilty, not guilty, or guilty with an explanation. So there's 2 forms of guilt automatically. And then you can say you're not guilty, but you got to prove that. So there's no innocence in there.
Yeah. It will always be brought to the attention that the issue was raised and the person has found himself as not guilty. Your innocence isn't even presumed once the matter has been hit, once the matter's on the record. Or
what the thing is they love to do too, what the magistrate will say, well, I'll enter a plea of not guilty for you. So by him doing that, or him coercing you into going with the matter at hand, now he has furthered along the case without you even knowing it, because you have agreed to let him decide whether or not you're in this court case or not.
And it's funny because that's that whole thing where the judge says that every people are in jail voluntarily because you've allowed him to what's that word I love to use? Traverse his position as a judge on the bench. He just practiced law from behind the bench, but because you didn't note it to be so, you ended up just getting folded into the system.
You let him be on your team as an attorney because he's representing you at that point.
Yeah, he just entered a plea on your behalf. Yeah, like you actually just said it exactly.
Yep, he acted as your attorney. Well, I'm gonna enter a plea of not guilty for you, just to help you out. He's like, no, don't. I was just gonna say they always, try to make it sound like they're helping you. It's like, oh, don't worry about it. I'll do it for you. I'll just enter a plea of not guilty for you. So, and then you're always like, the judge got my back. Yeah, okay.
Yeah. They wanted to throw the book at you, but they said, all right, if we can just slap him on the wrist, as long as it goes down as a W for us, it's all good. And he thinks we're on his side.
We did our best.
Man, the court tried to help me out. They could have gave me 10 years, but they just gave me the whole slap on the wrist with, some years probation and like a $1,000 fine. It's like, man, I could got so much, man. I'm grateful.
My lawyer's a beast.
Yeah.
All right, let's grab this one right quick. This is actually a good one. So in that last one, we just talked about how criminal. Oh, there it is. That's the one I was looking for. Because we just talked about how that last one noted that equity is not a criminal circumstance. So what they try to get you to do is to accept the jurisdiction before you try to make any claims to that. So in the next type of jurisdiction you'll see is they'll say it's an admiralty matter. If you get them to say that, that's hilarious.
They would never say that.
Over the jurisdiction is whether the offense was committed on a federal territory over which the state has retained concurrent jurisdiction. And even though, the state can't exercise any admiralty jurisdiction. And right there, you'll see the U.S. code right there that makes it known that the state can't practice admiralty jurisdiction on the men and women. So, that's another way to to battle that matter. And last but not least, they'll talk about a matter being in hustings, which is the true nature of action of all administrative law. So that's really what they're trying to whittle it down to at all times. And the easiest way to defend against that is the jurisdiction is that you're not an artificial person. So you're not, unless you are a federal citizen, but that's another matter. So unless they can show the record in the Secretary of State's office that you have chartered yourself as some sort of artificial entity, they can't use the matter and hustings to get you back into their administrative fold, because they want you on paper in the legal world. So if you ever claim basically any unity with your illegal entity straw man, then they'll just rope you in underneath that. But if you know better, you can easily stop that action from going forward.
What all these prove is that they only have one jurisdiction: business. Everything is done in business, in contract. So if you do not have a business contract with them, as Article 3, Section 2 of the Constitution for the United States says, they can only deal with things that they are in control of, that they have ownership of, which is citizens. Citizens they have ownership of. If you are not claiming to have any kind of business with them, well, then there's nothing they can really do. And the one thing, like I said, they'll try to do is keep you in court. They'll try to hold you. They'll try to do everything under the sun to try to force you to give them jurisdiction and to give them the win and the W. And it is up to you whether or not you want to stay fast in your own private capacity. Because you can always have the right to be in your own private capacity. They will always say no one forced you to do anything. Now, did they coerce you? Most likely. But they didn't force you. And that's why the higher courts will always, give a different decision than the lower courts. Because when you get to the Supreme Court level of states and federal courts, they don't want to go into that realm of being sued and getting disbarred, because that's a major thing. If you have a Supreme Court judges getting their bonds claimed for acting outside the Constitution, because now they just lost everything: their notoriety, their name, their honor. They cannot practice law anymore. They cannot sit on a bench. They cannot do anything. All they can do is look at court TV and be like, man, I'd have ruled differently.
Oh, man.
So, the lower courts, they don't really care so much, because what they usually do is just get a slap on the wrist. Like we said before, in one of the former casts, you can claim their bonds. Make it easier on yourself. Make it so they can't rule and make any another. To get rid of corruption, make sure there is no rulemaking that is outside of their jurisdiction. So what you do is get rid of anyone who will attempt to make rules and regulations and policy making that they cannot do. So you claim their bond and you get rid of them. So you want to fix the court system? Want to fix the how things are going? You want to get rid of all the bad cops and all this other stuff? Claim their bonds. It's up to you whether you want to do it or not. Don't tell nobody else, oh, they're not fixing it. Oh, they're not doing it. Oh, they don't want to. That's because that's their job. That's their business. Yeah. Like, who wants to destroy their own business?
Yeah. No, those goofy banners fix the system from within the system. Nah, man, it's a system. That's how it works.
That's literally how it works. It's a system. It just told you it's a system, but I don't understand. You said fix the system from within the system. So you saying I work for the system?
AKA business as usual.
Man, yeah. But all we try to do is educate and let you know, and show you the proof is in pudding, or as I like to say, because I'm get my dad jokes. Google it. It's in plain sight.
Yeah. It is. Y'all know what's going on, man. Google in plain sight. Hidden Black's Law, man. They giving it to y'all, man. It's right here. Everything is right there.
We showed it to you.
It's
He
in
said, don't
place.
take my word. Don't take his word. Use the court's word. They said it.
They said it, not me. Don't blame me. Don't get mad at me.
I need you to tell me that thing one more time, though.
Don't kill the
They-
messenger.
They either going to do it by threat, something, or coercion.
Oh,
Duress.
threat, duress, coercion.
uh,
TDC. TDC. Actually, when I used to sign paperwork, none of that stuff is legal, and I can prove it in a court of law, a higher court, actual court of law, because it's signed threat, duress, and coercion. I literally put TDC before any kind of signature because now it's saying I was under threat, duress, and coercion.
Oh man!
So I didn't actually sign it. I was literally being kidnapped, and they told me the only way they're gonna let me go from the kidnapping and is if we get this what they call it when you get kidnapped, the ransom. If they get this ransom, they'll let me go. So I'm just asking, my family or whatever to put up this money so I can because they ransomed me off, and I want to be let go. So please give me that ransom money they want.
Yeah. Wow, man. Wow. Yeah, man. Amazing, man. Amazing work, man. Good stuff. Practical application. It's right here for y'all, man. Hidden Black's Law, Google in plain sight. Thanks everybody for tuning in. We'll be back next Tuesday. Same time, same place.
Same bat channel.
Yeah.